Good afternoon, everyone. My name's Oliver May. I'm from the Bar Standards Board.
I'm Jake Arms. I'm also from the Bar Standards Board.
And I'm Verity Bell, and I'm from the Free Representation Unit.
So the format of this is we're going to kick off. We'll go through our presentation to tell you about the future of bar training, and then Verity will talk about through, and then we'll have questions on both at the end. So as stated, we're Jake and Ollie, and what we're going to do today is talk you through how the general approach has changed. Then we'll talk about the timelines and how it will impact you and affect you personally and directly, so what you should do dependent on how these changes are working. And then we're going to talk about a consultation we're running right now that affects future training. And then we'll take questions.
Great. So I know I've spoken to quite a few of you this morning. I can see some familiar faces in the room, probably because I told you to come to the talk, about the current approach and how to qualify as a barrister at the moment. Essentially, current approach is as is on that slide there. There's 5 parts to it with 3 major stages. The first part is your academic stage. So this is either a undergraduate law degree or any other law degree combined with a graduate diploma in law or some other qualifying law degree. This is the stage which a number of you, which I spoke to this morning, are at, and is usually the university stage. Then, after that, you need to complete what's called the Bar Course Aptitude Test. Now, this is essentially a verbal reasoning, a logic test to determine whether or not you've got the relevant aptitudes to be a barrister. And you also need to join an inn at that point, one of the 4 inns of court. Once you've done that, you can then enroll on and begin the bar course itself. The bar course is a year for full-time students or 2 years for part-time students, and will cover the vocational studies that you'll need to cover off to be a barrister. This includes training on drafting, opinion writing, advocacy, civil procedure, criminal procedure, and so on. Once you've completed that, and usually during the final year of that course, you'll begin applying for pupillage at a chambers, or as is put on the slide up there, work-based learning, because there'll be all sorts of various ways of doing it. Pupillage is the most common. So the work-based learning is a year of, at the moment it's a year of training which you do within a chambers where you learn the skills and put them into practice, usually within a first and a second six. Depending on the chambers you're going to, it might include a third six, which might be mandatory or optional, depending on the chamber's requirements themselves. That covers off all of the various educational steps that you need to become a barrister, and it's the current approach and the approach which most of you would have been looking at prior to what I was about to tell you.
So we have changed the way bar training works. I know, terrifying, Alex. The main thing to think about is the fact that the old system, the current system in fact, was an authorised training route. There was a vocational element, there was an academic element, there was a work-based learning element. None of that's changed in essence. There will still be an academic stage, there will still be a vocational stage, there will still be work-based learning, but they can be mixed in together, they can be combined, they can be in different orders perhaps. There could be, for example, an apprenticeship model where you leave school and you join some chambers potentially or some other organisation at the age of 18, 19 years old, and they train you all the way through every one of those stages. Or there could be a combination of the academic and the vocational, so a combined degree in BPTC, as we'd call them now. Or there could be a combination of the vocational portion with the work-based learning portion, so someone teaches you effectively what's on the BPTC now while you do what would be sort of a pupillage at the same time. The purpose of this really is to make bar training and the ability of someone to become a barrister more flexible, more accessible, more affordable, but while also maintaining the high standards. So what's really changed is that we have decided to be less restrictive on what qualifies someone to become a barrister. Just before we move on, that can still be the old model. So it's important to realise we're not getting rid of that old model. We're not saying you could no longer do academic, vocational, and then work-based learning. That could still, and probably will still be a very popular version of the future training system.
So practically, for each of you, we've broken down how this is going to work based on year of graduation so that you have a clear picture of how it's going to affect each of you individually. So for those of you who are 2017 university graduates in the room, so people who will be graduating this year, you are currently at the end of the academic stage. And you will then be moving on to vocational and then work-based learning. The changes won't be coming in until early 2019, so they won't have any significant impact on you personally.
Yeah, so as Jake has mentioned, those changes, all the rule changes we're doing right now, all the rule changes we're considering will come in January 2019, with a view for those to start applying and affecting the way training is delivered in September 2019, which means if you are a 2018 university graduate, you will now be subject to a slightly different training system. So your vocational course will come into place. Your vocational training might change slightly accordingly. If you start the BPTC in 2018, it will still be the current BPTC, but by the time you start your work-based learning or your pupillage, there might be new rules regarding what that pupillage entails or how it's run, but we'll come on to that a little bit later on.
If you're a 2019 university graduate, it's going to have more of a profound effect on you and your course to the bar. So the academic stage will remain the same because the changes come in at the start of 2019. But from then onwards, the work-based learning and the vocational learning could be offered in a number of different ways. It might be that there's a combined solution which provides both work-based learning and vocational education, or it might be that you follow the traditional path and do a BPTC and also work-based learning or pupillage after that. Both of those types of models may exist, and it'll be down to providers to provide various different solutions to that. So if you are a 2019 graduate, it's the second and third stages and the way in which those are changing which will impact on you.
And what if you aren't even an academic at the academic stage yet? What if you're not studying a degree yet? What if you're doing your A-levels, in fact, right now? You might be subject to all of the changes coming into place. I've seen at least one person who was pre-A-levels today, and she will be subject to the entirety of the new training rules. She may be able to access, for example, some sort of chambers or employed bar system where they offer an apprenticeship model all the way through training. So really, to summarise this is all about making it more flexible and more affordable, maintaining high standards the entire time, but making sure more people are able to become barristers and are able to train in a way that suits them and their needs as well.
So, second part of today's talk, becoming a barrister. At the moment, there are a series of requirements and a series of optional steps that you can take to become a barrister. I've talked through a number of these with various people who approached us this morning. The mandatory ones at the moment are on the left. So you must have a 2-2 in a degree. You must pass the bar course aptitude test. You must join an IN and therein complete 12 qualifying sessions. You must complete the BPTC and you must complete pupillage. Then on the right-hand side of the slide are a number of optional steps. These are things which I'd highly recommend you look into doing. These are things which will help you when it comes to writing applications and demonstrating that you have the skills and competencies to be a barrister. They include doing mini pupillages, various areas of work experience, whether legal or traditional, just standard work experience, and being able to demonstrate the ability to manage your workload and so on. Pro bono work, for example, the free representation unit, which we're going to hear about in a moment. Debating and mooting events so that you can demonstrate advocacy ability. Networking events, either through your IN or otherwise. Scholarships and awards, again, through your IN, your provider or otherwise. And potentially even joining a bar association or any number of other steps which will assist you in demonstrating skills and competencies. We do have a current consultation out at the moment on tweaking some of this.
So we've already consulted on and thought about rule changes for those things which have just faded, on the left-hand side, that is, namely the degree, the BPTC, and so on. We are currently considering a few other options, a few other issues, including the relationship that students have with the inns. It will also include things like how pupil supervisors are trained, how the pupil supervisor to pupil relationship works, whether it's mandatory to join an inn to become a barrister, or whether it's necessary to do 12 qualifying sessions. Now, the important thing to mention on this is that the BSB doesn't really have a position on this as such. There is an open consultation right now. We are interested in hearing your views, and if you'd like to learn about how you can tell us about what you think, whether joining an inn should be mandatory, whether qualifying sessions are necessary, please come find us in one of the hallways, and we'll happily talk about how you can reply to that consultation.
The consultation also has a number of other points which we're not going to take you through now. I think there's something like 50 questions on the consultation. Not a lot of them will be applicable to you. They apply to things such as pupil supervisors and all kinds of other idiosyncrasies in that. But there are some other consultation points that you're going to want to look into potentially. Pupillage funding changes, whether or not we should increase the minimum funding requirement, whether or not we should allow for flexible pupillage duration lengths, whether or not there should be shorter or longer pupillages, whether we introduce DBS checks, and whether or not qualifying sessions should be restricted to only be provided by the Inns of Court. A number of other possible changes on top of those, all of which are contained in the consultation and will be relevant to a lot of you. Highly recommend looking at that consultation document, at least looking at the parts which you consider to be relevant to you.
So this is for the BSB. Currently, as you know, the knowledge exams, the 3 knowledge exams on the bar course are centrally set. Under the proposed new system, how would you ensure standards are maintained in the more practical-based topics such as drafting, etc.? Because obviously currently the providers do the examinations for those. Would those be centrally set as well? Would the providers have to provide them for people not doing the course?
Okay, thanks for that question. Standards obviously are very important, and maintaining high standards is one of the key principles of the future bar training system. It's important to realise that this won't be a free-for-all. This deregulation is in aid of enabling a wider array of training options, but each of those training options must be up to standard. So how it will work is we're in the process right now of writing something called an authorization framework, which I don't recommend reading unless you are a training provider. And that sets out what we need a provider to show in order for us to authorize their training system. And within that, there must be guarantees of quality and of the standard that people will come out to the end of that training with. So it may or may not involve drafting exams or opinion exams, but it must enable students to become able and indeed highly competent at drafting and writing opinions and so forth.
So could a provider be a Chambers?
A provider could potentially be a Chambers, yes. It's a complete overhaul in that sense. So there's no, as long as they're authorised by the BSB and you go through an authorised training route to become a barrister, there's no provision that they have to be of a certain category or otherwise.
Any questions at the back that we can't see? No? No. You got another one for us?
Yeah, sorry, me again.
No, fire away.
Obviously, it's a good idea to get, for instance, Chambers interested in providing an apprenticeship route. However, how are you going to incentivise them to? I just know that a lot of Chambers now, for instance, offer pupillage at the minimum level. And unlike law firms, maybe there isn't the impetus for training future barristers. How would you encourage Chambers to take on the apprenticeship route?
That's a very tricky question. I'm not going to pretend otherwise. The incentive, I don't think the BSB, I don't want to tie the BSB down to any specific answer there. I don't know truly the answer to that question. I would say there are a lot of incentives already for Chambers to train people right from scratch, because a lot of the things we hear from Chambers right now, the BSB and everywhere else, is that once they get someone in on pupillage and during that work-based learning stage, they need to teach them an awful lot about how their specific area of law works and the quirks of their specific area of law. So if you do family law or chancery law, There's not a lot of that necessarily on the BPTC at the moment, and so you might need a lot of training in that area. So the incentive, I think, is innate in that chambers can take someone right from the very start of their legal education and train them all the way through to be what they think is the perfect barrister for their chambers. I'm not aware of any additional incentives the BSP will be creating.
Actually, another question for the Bar Standards Board. I was actually called to the bar about 20 years ago and never did pupillage, and it's something I'm now coming back to. I just wanted to know what the options might be for someone like myself in the revised scheme and training proposals, rather than maybe just a straightforward pupillage application.
So at the moment, your options are twofold. One is you can redo the bar course, and then you will have a new 5-year period within which to find pupillage. Or, depending on your circumstances, you can apply for a waiver for the period of 5 years and say, look, I've been called to the bar, I've done X, Y, and Z, I'm therefore sufficiently qualified to be able to go to pupillage immediately. That's obviously on a case-by-case basis, and it depends on your circumstances as to whether or not you can do that. You need to speak to our authorizations team about that. In terms as under the future model, when you have the future bar training proposals coming in, I'm not aware of any changes in terms of the process of authorizations, but I don't know. Is there any further changes on authorizations?
No, I don't think
think
that
so.
element of it would change.
It's more about the education process itself rather than the authorization requirements. So you would need to demonstrate the necessary competencies. It might be that you could do something other than a BPTC to be able to do that. That really depends on what options come out of the providers for that.
Well, that question does raise an interesting point, though, which is important to note to anyone in the room who's already been called, which is that the changes to the way bar training is provided and will be provided in the future do not affect your call status. You are still called, you will still be called, no matter what changes end up being made. You are still eligible for pupillage. You don't need to do any extra training because of this.
I have a question for the bar standards.
Great.
Obviously, one of the criticisms of the current system is that the BPTC is prohibitively unaffordable. How are your changes going to make it more available to people who might not be able to afford the BPTC?
So one of the causes in any market regarding affordability is a very restricted way of accessing something. So if there's a high demand and low supply of something, the price will be very high. It's also the case that the bar course, I believe, is very expensive to run. So while we are not specifically doing anything that will directly impact price, by making it more flexible, we are hoping that new training pathways will emerge that will be more affordable. That's sufficient.
It's really a case of whether or not providers can use the tools that we're going to provide them with such a way to generate a more flexible approach and a more affordable approach. It's really whether or not they could be creative with the removal of regulation over certain aspects of provision. And if they are able to be creative enough for better, more affordable options, then of course those will have market incentives and are likely to be chosen by candidates for the process. So there's obviously a market incentive in doing that. So it's really a case of whether or not they can come up with a creative solution that allows them to offer a more affordable option.
Anyone got any more questions?
Oh, there's one at the back there.
There is a concept floating around, or the idea that after you get called to the bar, you have 5 years limitation period before you're able to get pupillage, and then that expires, and supposedly you have to do the BPTC for it again. But it's never really been explained or elaborated on as to how exactly that works, or who can be exempted from that 5-year limitation period, or how it can be, I don't know.
Sure. So educational requirements, any of them, in terms of exemptions and waivers, that's something which is done on a case-by-case basis. So you can get things such as exemptions from certain parts of the course, you can get things such as exemptions for time limits, You can get things like exemptions for length or parts of pupillage. So some exemptions include a shorter pupillage period. Some other exemptions include not having to do civil litigation if you're already a solicitor. Certain things like that, but it's done on a case-by-case basis. And it's entirely about the experience that you already have and whether or not you can demonstrate that fills the requirements that would be met by completing the full course. So it's not as if I can simply say, your specific circumstances, you will get this. It's really a case of making an application to the Bar Standards Board and allowing them to assess the competencies and skills that you have and to see what waivers can be done. If you have any questions about that, feel free to come and talk to us afterwards, and I can give you the contact details of the people you need to speak to get more details.